Hello, my name is John Milburn. I'm one of the course coordinators at Central Queensland University. Thanks for joining me in this course. I'd like to speak to you briefly about the focus of the course, thinking about being a lawyer and the study of law. The focus of the course is primarily for those who wish to practice in law, or at least be in a position to engage with or instruct those who do practice in law. When it comes to thinking like a lawyer, there's a quote from The New Lawyer, which is a text by James and Field, which I particularly like. And they say that thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. Think about that not only in the context of practicing in law, but also studying law. There will be times where you feel overwhelmed, that there seems to be too much reading, and that you seem to be constantly subject to a barrage of information from a number of different sources. We make no apology. It is difficult to work your way through those issues, but you need to find out techniques that will help you. One thing I particularly like to do is think about the end objective. What is it that you're trying to achieve at the end of the day? And perhaps you can work backwards. Sometimes thinking in reverse order will help you to go about achieving your aims in a logical and progressive way. With the benefit of hindsight, would you consider doing things differently in relation to matters in the past? And perhaps now you might think about how you'll feel about this course when you get to the end of it, and think to yourself, had I been able to go back to the start, are there things I would have changed? So think about the techniques that will help you to avoid easily avoidable mistakes that may confront you. Let me give you an example, very simple. My wife sends me a text. I'm at work, it's very busy, I've got a lot on my mind, but she's not well and she asked me to bring home takeaway. I arrive home, I have no takeaway. How do I feel? What's the cost to me? I've let someone down. I've let myself down. So what should I have done in hindsight to avoid what is really an easily avoidable mistake? Well, I used the old keys in the fridge technique. It all started when one day I was required to bring home some milk that was left in the fridge at work. And what I did immediately is I put the keys in the fridge. I then went about doing all those other things that I needed to do that were important. And when I went to go home, I couldn't find my keys. It took me 5 minutes to realise and remember that they were there. But the fact that it took me so long to remember that the keys were in the fridge guaranteed, as far as I'm concerned, that I would have forgotten the milk had I not done that in the first instance. So what am I trying to say by this simple analogy? There will be plenty of times where you have things that are important that you know need to be done and you don't want to miss it. So take the opportunity there and then to put in a simple technique to ensure that you've got some safeguards, probably some practical safeguard, and whatever it is that works for you. That way, when you get to the end of the course and you've missed an assignment or you've missed an opportunity, you won't be regretting and cursing yourself for having done that because you've put in some safeguard. All right. In law, we need to communicate effectively and clearly. How do we go about doing that? Things have changed. I'm going to ask you to consider two ways of saying essentially the same thing. Please let me know which one you prefer. Here's the first one. Thank you for enrolling at Central Queensland University, where during the course of your studies, you will be encouraged to interact, communicate, and enter into written and verbal dialogue, perhaps singularly or perhaps in a supplementary alternative fashion within a group session with not only lecturers and course coordinators, but also your fellow students and other interested parties and stakeholders from time to time. You will be called upon from time to time in a written and verbal format to communicate in a number of different ways and to a number of different people, perhaps identified individually or as a group, or perhaps in a more general sense to members of the interested public. During the course of your studies, you will be encouraged to become super efficient with your verbal and written projections. Now that's one way of saying things. How about the alternative? Communicate simply and effectively. I think the second's the better alternative, but see what you think. The point of that exercise is to suggest that simply having a lot of words on the page or talking for a long time does not necessarily improve. In fact, it might be a detriment. So think about what you say, think about what you write, and communicate simply and effectively. The trend in law now is to avoid gobbledygook, to avoid legalese. Gone are the days where pretentious, archaic language is generally used in legal communications. We don't do that anymore. So forget about the Latin terms. People who might say, I refer to your communication instant, which I think means yesterday or under consideration. Just talk naturally. My background is, apart from being a course coordinator at this university, I'm a lawyer in private practice. I was admitted in 1984. I studied at the University of Queensland in the 70s. It's fair to say that I've practiced or studied law every day of my life since about January of 1977. Apart from being a lawyer in private practice, primarily in litigation, I'm a commissioner for the Crime and Corruption Commission, member for the Queensland Civil and Administrative Tribunal. I'm nationally accredited mediator. I'm a preferred supplier of legal aid services, currently president of the Fraser Coast District Law Association and member of the Fraser Coast Anglican College Council, former chair. So I guess I just want to say that I've got a wide background, and I'm very happy to try and share with you anything that might be of interest to you in terms of that background, to the degree that I can, in terms of confidentiality, of course. Look, I want you to be prepared for the course. I want you to take every opportunity to update your study and keep up your reading. There is a lot of reading, so get something organised that will help you. Look, there's a great quote from a former student of mine, Annalie Sullivan, who says, I've spent the last few days downloading ebooks and documents and resources onto the laptop and the Kindle. I love the Kindle. I can carry all my textbooks in my handbag. I also have downloaded the guide to legal citation and many other documents onto it. I can read on the go, wherever I get a minute, even if I'm just waiting to pick up the kids at activities. Uni in my pocket. That's a great quote, so thank you, Annalie. Finally, in this session, I just want to talk to you about the study of law. It's not an exact science. You probably know that. It's not as though necessarily there will be a right or a wrong answer. I'm much more interested in your ability to argue a position. And of course, in legal litigation, we're trained to argue a position, not necessarily to say what the right position is when we're in court. We have that role in providing advice to our clients beforehand, to the best of our knowledge, but when we're in court, we're arguing a position. Now, studying law. There is no such thing necessarily as the law. The law, if you like, is fluid, it's cyclical. So overwhelmingly, the most important part of our law now comes from legislation. That wasn't the case. Many years ago, the common law, case law, law made by judges, was probably more important in terms of what constitutes our law. So the law changes, that's pretty obvious, and most of it now is driven by Parliament. And parliamentary law takes precedence over judge-made law. However, Parliament makes a law. The law can be supplemented by delegated legislation, which is through the executive branch, but as you might understand, it would be impossible to make a law or series of laws that cater for every possible circumstance. So circumstances arise where people argue about what the law is or means or how it's applied in a circumstance. So lawyers are engaged, the matter goes to court, the court then interprets a law, and even then the judges may disagree. There may be a split decision. There might be an appeal against an original decision. And just because in the High Court, 3 of 7 High Court judges disagree with their colleagues, 4 of them in the majority, that doesn't mean that the 3 that gave a decision contrary to the majority don't know their law. Quite the opposite. It just goes to highlight that different people can interpret the law in different ways, which goes back to my original point that your role is to really argue your position. Anyway, we have judges interpret the law, they come to a decision, the community and Parliament might react to that, and Parliament might go and create new laws which clarify the position or overturn the position taken by a judge in interpreting previous laws. So the law then changes as a result of that. And then, of course, we have an election, we have a new government, and Parliament will repeal old laws and bring in new ones. So law is constantly changing, and it's always subject to interpretation by courts and tribunals. And remember, of course, that they are people, so they have potentially different views. The study of law then is better described perhaps as a study of legal process. It's not necessarily the study of the law. There's not necessarily going to be a right or a wrong answer. So therefore, a lawyer who says, I'm not sure what the answer is to that problem, could perhaps be wanting in legal knowledge, or conversely, may have a great deal of legal knowledge. So do be aware or wary of a simplistic answer. Be careful about thinking in black and white terms. Paralegals, as great as they are, can be guilty of thinking in black and white terms because they're trained primarily in a certain area of law and not necessarily all of it. Remember that there's a distinction between what we call the black letter law and equity, which deals with issues of fairness and provides alternative ways of dealing with a dispute. And when it comes to having right or wrong answers, just be concerned about, or I have concerns about mandatory sentencing, because when Parliament makes a mandatory sentence, it's not possible, I think, to cater for every different circumstance and in every individual's circumstances. All right, so just finally in this session, I'd like to say that advocacy is not necessarily a process of ear bashing or foot stomping. It is a matter of persuasion. And a couple of things flow from that. The first is that sometimes due concessions should be made. And the second is that many of our very best advocates and barristers are quietly spoken and persuasive. And keep that in mind during the course of your studies. Thank you for listening to this session, and we'll speak to you soon. All the best. Bye.